We're back with our monthly legal segment where we talk to a local attorney about issues that affect you. Today we're talking about adoption in Oklahoma, and joining me right now is attorney Alexis Gardner. Good morning, Alexis.
Good morning, Dave.
So adoption in Oklahoma, first of all, generally, do you need an attorney to adopt?
Yes. Adoptions are very complicated. They can take a minimum of 6 months. There's a lot of legal paperwork. It's a complicated process, so generally you want an attorney. The one exception is if you are a foster parent through DHS and you have a child already in your custody and then you're moving to adopt them. You don't need an attorney in that case because through the deprived court, the child is already appointed an attorney, the biological parents have an attorney, the judge is already familiar with the case. So in that case, the system and the process goes a lot smoother. But even then, sometimes foster parents get an attorney if they want to proceed with an adoption of a child.
You know, we have a lot to get to today, so I put this graphic based on kind of what we had talked about beforehand about where we're going. The first thing, talking about biological parents. If the biological parents are, still alive, if they're still in the picture, let's talk about adoption with or without consent. What does that mean?
So adoptions, like I said, are very complicated. They can be less complicated if both the parents consent. If they don't consent, that's called an adoption without consent. We call it AWOC for short.
AWOC.
Yes. But essentially there are 3 reasons that you can proceed to adoption without consent. If there's been abandonment by a parent, if the parent has not paid child support for 12 consecutive months, or if they've failed to maintain a substantial relationship with the child for 12 consecutive months. So an adoption without consent, for instance, say I get remarried and my ex-husband doesn't call for a year or pay any child support, then my new husband can proceed to adopt my child without consent. However, there's still notice to the parties, still that ex-husband gets to be noticed and heard in front of the court if he would, like to contest it or what have you. And so adoptions without consent are more complicated. But even with adoptions with consent, say it's a mother who doesn't necessarily know who the child's father is, she still has to put on notice the potential fathers. So if she doesn't have contact information for the men who might be the fathers, you have to pay for publication in the newspaper.
Wow.
Really making sure everyone is on notice before you do something permanent like consent to your child being adopted.
These are obviously weighty legal questions, and of course we usually only have 5 minutes left, but we have 2.5 minutes. I do want to talk about the open versus closed adoptions. It's also part of the graphic that we put together here. Open versus closed adoptions. What does that mean? So
most adoptions are closed, meaning the child and the biological parent never have any contact. Once the child turns 18, though, they do have the right to access that parent's information, so they can find out about their social history, any contact information if it's available. And then there are open adoptions, which is essentially a contract where the adoptive parents and the biological parents come to an agreement on what role the biological parent is going to play in the child's life, if they're going to be an aunt and have visitation once a month or what have you. However, it is a contract, and contracts can be broken. So even if you agree to an open adoption and then the adoptive parents don't abide by the contract and let you have the contact that you wanted to, you've still already consented and relinquished your parental rights. So your child is adopted by those new parents, and they can decide how much access that bio parent will have to them.
We have about a minute left. Obviously, again, another big question. The Indian Child Welfare Act, ICWA. We've done news stories here on News on 6 many times over the years about the ICWA. Some guidelines for parents if you're hoping to adopt a child who is Native American. What do we need to know?
So IWCA, we can say ICWA for short, and essentially Native children have more rights than other children as far as the tribal interest. So the tribe has to also be on notice and agree to the adoption of this Native child. Preferably, the child will go to Native adoptive parents, and if you're a parent who has consented, a biological parent who's consented to adoption of your child, you have more rights as far as revoking your consent. So say you've signed off on all the paperwork, but the child still hasn't been legally adopted yet, you have more standing in court to change your mind. Whereas if the ICWA Act doesn't apply, then that consent is irrevocable. Of course, there's avenues to appeal the adoption. However, it's a much more uphill battle if you're not native.
A lot to keep in mind if you're considering adoption. Thank you, Attorney Alexis Gardner. Alexis, thank you so much for joining us.
Always a pleasure.